Values friends, Jonathan Sines here, President of Texas Values. I'm joined by Policy Advisor for Texas Values, Mary Elizabeth Castle, also Director of Policy, Jonathan Covey. We want to give you an update on a case you probably heard about today. A lot of people in the news are talking about it. Since we're in June, it's very often that we get decisions from the U.S. Supreme Court. And quite often, as it relates to issues that we work on faith, family, and freedom, those cases get held up until June, because that's really the end of the term of when the Supreme Court releases those cases. And a lot of times people think those are the most toughest or controversial cases. So we've kind of gotten used to Supreme Court decisions coming down in June on issues we work on. And that was no different today. So today, the court released a decision in the Bostic case, and it was actually 3 cases combined. And I'm going to talk a little bit about that in a minute. But the overarching theme here is a 6-3 decision. This opinion was written by, and I'm getting some audio. I don't know if that was my phone or video. I'm going to close my laptop here just in case. But a 6-3 decision from the U.S. Supreme Court written by Justice Neil Gorsuch in a majority opinion stating essentially that sex has been redefined to include sexual orientation and gender identity in employment discrimination cases. Now, one of the reasons we're doing this video live with the decision coming out today is because we want you to know we're standing with you on this issue. And not just to talk about it, but we also filed an amicus brief in this case. And what that is a friend of the court, a legal brief, where we talk about what our view is on this issue. And our view was in support of one of the 3 cases, and this was the Harris Funeral Homes case. In particular, one of these 3 cases that we were involved in and submitted a legal brief really supporting that sex should not be redefined. And a big decision about this and a big concern was the fact that the court overstepped its bounds and really legislated from the bench to make the decision. We're going to talk about that in just a minute. But and you might be asking yourself questions about this issue. So that's why we wanted to bring this video so you could hear a little bit more about the case. But no, there will be more that we will talk about moving forward. And just so you know, a couple of things about this case. The Harris case came out of the state of Michigan, and it dealt with specifically an individual, biological male, who eventually started presenting himself as a female. There was a particular dress code in place that the employer had that had been in place for quite some time and had been a part of following the law and the ability and the freedom to do that. And that was part of what got called into question. But a number of sources are already talking about this. One of the main entities that worked on this case was Alliance Defending Freedom. They've got some great information that they've already put out on this on social media. And what they said essentially is what the court did in this case is simple. Legislation. Key there. The court, legislation. Doesn't match up, right? Redefining sex to include gender identity and sexual orientation creates chaos and is unfair to women and girls. We'll continue to work to protect the freedom of America to live and work according to their faith at the federal, state, and local level. Also want to just mention what another individual you may be familiar with, Ryan Anderson from Alliance Defending Freedom. He says, in fact, from the Heritage Foundation, he says, in fact, Congress has repeatedly rejected legislation to redefine sex on these issues of sexual orientation and gender identity that would have added sexual orientation and gender identity as protected classes. The Supreme Court has simply legislated from the bench, pure judicial activism, very similar to what we said. And we pointed that out in our statement because Congress has been asked before to redefine sex under Title VII to include sexual orientation and gender identity, and that's been rejected. It's never passed the House and the Senate together at one point to make it to the president's desk. There's never been a law in the state of Texas that's reached the governor's desk, no less past the House or our Texas Senate. So really important for people to understand what's going on. And we've talked to you about these issues. Not only have we been a part of filing briefs, we've been fighting some of these issues at the local level, a lot of times with victory, but sometimes with setbacks. And so that's a big part of what we do. But I want to bring Mary Elizabeth in. Let's talk our press release, but let's talk about some of the examples and the concerns of
Right, Jonathan, there will be chaos, and I think this decision was very short-sighted because there are very dangerous implications of what was decided today. You've heard us talk a lot about the fairness in sports issue. Now, that will not only apply to high school girls in sports, but it could be far-reaching to collegiate sports. And even as Justice Alito mentioned today, professional sports as well. There are clear differences, biological differences between female athletes and male athletes in advantage, especially at the high school and collegiate level. However, because sex is being redefined today in employment law, that could mean that a man who identifies as a woman could compete on a women's sports team and have either a dangerous advantage, or there could be instance of injury, like we saw in the one case where MMA fighter, male, competed against a woman and actually cracked her skull. There could be the issue of homeless shelters. We mentioned this numerous times, where if you do not clearly define sex, and many homeless shelters actually have rules where they keep women separate, not only within the homeless shelter, but some homeless shelters are actually for women and children only, to protect them from some things that they experienced before. However, we've seen instances where transgender individuals or individuals who identify as women who are biologically male try to enter into these shelters. If we redefine sex, then they would have to allow those people in. We also see the issue of pronouns. I mean, you look everywhere and people are coming up with new pronouns besides he and she. It's not even just the issue of whether or not someone prefers a different pronoun than what they biologically are, but there are added pronouns besides he, she, and they, including ze and zay. And so if you were someone at work who used a pronoun based on what you see and not what the person identifies, you could be in trouble for not using that particular pronoun. We even heard of a teacher down in Florida who actually got in trouble for using the wrong pronoun. Then you also have the healthcare issue. You saw how under the Affordable Care Act, how even there were special definitions for sexual orientation and gender identity. So as an employer, under this new rule, you would have to pay for gender transition surgery, or maybe even puberty blockers for children. So there's a lot of chaos and a lot of dangerous implications that are far-reaching in your daily life. And it doesn't just affect a few people, it can affect everyone.
Well, and I want to make it clear, too, whatever the Supreme Court has done and what people are going to suggest it is doing or should be doing, none of this changes our state statute. The state legislature in our state has not rewritten any laws at this point. So it's very key to keep that in mind, nor has Congress. And so, it's not uncommon when you see a Supreme Court decision where there's judicial activism, where there's an overreach of their authority for the Congress and state legislatures to respond. And if you want to talk about this on social media, some hashtags we're seeing from our friends at Alliance Defending Freedom: sex, not gender; fair play; save women's sports. Speaking of this decision, I want to bring Jonathan Covey in, our Director of Policy. This court decision, including the dissents, over 170 pages long. And we're not going to go through all that in this video, but we will break forward to give you some more intel. But one of the things that we saw in there was some back and forth, if you will, between the justices on a very key point.
Yeah, Jonathan, and you said this before, and Ryan Anderson said it, that legislating from the bench is a phrase that's been used by many organizations, and that's exactly what the justices were doing in the majority opinion on this case. But even more telling than organizations, other organizations saying it is when a Supreme Court justice comes out and dissents and calls out another Supreme Court justice and says that you're legislating from the bench. And I want to read you real quickly just a short excerpt from Justice Alito's dissent to the majority opinion, which we were all surprised was written by Justice Gorsuch, who was appointed by President Trump. But Justice Alito said, "But the authority of this court is limited to saying what the law is. The court itself recognizes this. Quote, the place to make new legislation lies in Congress. When it comes to statutory interpretation, our role is limited to applying the law's demands as faithfully as we can in the cases that come before us," unquote. And he said, "It is easy to utter such words if only the court would live by them." And that's Justice Alito calling out, and just an incredible call out, saying that Justice Gorsuch, you and the majority are not living by those words, and you're legislating from the bench, which is exactly what originalists shouldn't be doing.
Well, look, and you mentioned this in the beginning of your comments, Mr. Covey, I like to say, to Jonathan's here, but that it's not another advocate, and not to suggest that we don't have some value to the words we say and some credibility, but it's at a whole nother level, if you will, when a fellow justice is calling out another justice in the dissent. And as I mentioned, these opinions all together and dissents and so on, quite long. And so there's some really interesting things to read in there, and we encourage you to do that. But yeah, Justice Alito calling out Gorsuch on this issue, and these are fundamental principles, regardless of what the issue is, about the role, the appropriate role of government. And that's why it would be no surprise, and that is our charge, and where we stand on this issue is Congress should respond. Our state legislature should respond, and we encourage you, contact your state or federal level official and let them know that you do not support this decision and that it should not be forced upon us here in the state, particularly, and one of the reasons, because you have another justice obviously having tremendous concern with this issue, and that's part of what we do. Part of what we do at Texas Values is helping you get connected with your elected officials, helping you communicate with them, letting you know what's going on so you can tell them, this is important to me. This is a case and an outcome that we definitely think you need to let your local officials at the state and federal level know this case is important to you and that you're very concerned with the outcome of it, and that to remind them there is something they can do about that. There's history where we've done this in the past, where you've had the courts overstep their bounds and Congress or state legislatures have come in and they've taken that authority back that was taken away from them. But that's a part of what we're going to continue to do, is communicate to elected officials. As a matter of fact, I have communicated to state level officials about what we're saying on this issue, what our concerns are, and we'll continue to look and see what happens on these issues, whether we hear the governor say something, we hear our lieutenant governor say something. We've communicated our concerns on these issues, but that's a part of what we do. I want to talk a little bit about some details as it relates to churches and religious nonprofits, because you're likely to hear and you might be one of those. You might run a religious nonprofit, you might work at a church, you might be a pastor or lead a church. We've been communicating a lot more with churches and pastors during this time as they've been trying to navigate what's going on with the coronavirus. When can they open and all that? And now you've got this decision coming up. And so if you've got questions on those things, let us know, because we would love to be in a position where we can help you answer those questions. So you can send an email at info@txvalues.org. info@txvalues.org. And there's a little bit more to know on this issue too. There's some decisions that are expected to come from the U.S. Supreme Court on what's called the ministerial exception. Those are issues that relate to what churches can do and how laws apply to them, and how it's different because they're a religious nonprofit or they're a church. And so we might hear, we're going to hear something more from the Supreme Court that might impact some of those things. So we don't have everything to tell you just yet, and different things can apply different ways. And so we want to let you know we're here for you to help you answer those questions. That's one of the reasons why we're in touch with our national friends that have been doing a fantastic job, like Alliance Defending Freedom. We were on a private call with them earlier, breaking some of this down. And so we'll continue to be engaged on these issues to find out what's the best methods of moving forward on these issues. And so, we've been communicating a lot to pastors and churches on their religious freedom rights.
Yeah, absolutely. And we know that there are things that come up on a case-by-case basis. So we're always here, we're always available, and if you want to reach out to us at info@texasvalues.org, please do. We'll be here and we'll work with you individually and talk with you.
Well, and Mary Elizabeth, you've been communicating, you've been doing a lot of great work. One of those things, though, has been communicating a lot with the pregnancy centers. You might have some pregnancy centers that are religious-based, that are nonprofits, and wonder if some of this stuff could be applied to them and how they live out their faith and how they operate things. It's possible that it could be questions they might be asking.
Yeah, that's true. There are a lot of nonprofits, and pregnancy resource centers are a part of those nonprofit organizations. So if you have any questions about how this affects you, how you carry out your business, especially since a lot of pregnancy resource centers are religious based or have religious connections or funding, please email us at info@txvalues.org and we can answer that question for you.
Well, and look, as I said, as we move forward, we're going to be looking more at this issue. We're going to look at some recommendations we may have of how things should work on this issue. I think one of the most important things you can do right now is to communicate with your state and federal level official and let them know that you do not support this decision, that it's a concern of yours, and you're ready to stand against it. We know other groups have already been pushing for statewide legislation on sexual orientation and gender identity. And one of the reasons is because they couldn't get it passed by Congress and they couldn't get it passed by the state legislature, so they keep pushing it. And so they may want to suggest that because of the Supreme Court ruling, there's nothing for them to do at the state level and elected officials don't have anything else they can do. That is not true. And we're here to help you navigate that and to put a little bit more strength behind that. As we conclude, though, let's not forget there's also an individual business here that relates to this issue that was just trying to follow the law as it's been stated, that was just trying to run their business based on standards that had been in place for quite a long time. And now they could find themselves in a very difficult situation as this litigation has gone on for quite some time. We know there's a lot of stories of businesses that have been devastated. And frankly, there are some people that push LGBT advocacy. That's exactly what they want. They want to use the government and decisions like these to punish businesses, to put them out of business and make it difficult for them to operate as a way to punish them because they simply have a biblical view or they see these issues differently. That's what they've been using some of these resources for. So don't forget about that. So be in prayer about those things, but also if we can help you in any way, go to info@txvalues.org and email us at info@txvalues.org. Your questions, we will do our best. If we can't answer the questions, we'll reach out to some of our friends at the national level and others to help you get connected, to give you some insight. Look, this issue's not over. There's no question about that. This decision today does have its impact, and it does have its significance. And frankly, I know for many people, it was a surprise. But now here's where we are, and we'll be working together with you, with our team, and people all across the state about how we respond to this issue and how we put you in a position to help communicate with your elected officials and those other people that work for you and how they can continue to represent your values for faith, family, and freedom. And if you want to continue to get updates on our work, go to txvalues.org to find out what we're doing at Texas Values. And we'll have more updates for you soon.